to this edition of Practical Probate. Today I'm going to talk about fiduciary liabilities under powers of attorney, trusts, and decedents' estates. I'm Dom Calabrese. Since 1995 I've been a Connecticut attorney, and since 2003 I've been a Connecticut probate judge. The purpose of Practical Probate is to give you information, not to give you legal advice. And none of the information that I'm providing in this video should be construed or relied upon as legal advice. For legal advice, you need to see a qualified attorney. In this presentation, I'm going to talk about what a fiduciary is. I'm going to talk about some common fiduciaries, give you examples of them, look at liabilities and responsibilities of fiduciaries, talk briefly about pertinent elements of Connecticut law that apply to fiduciaries. I'm going to talk about self-dealing, signs of trouble with fiduciaries, how to choose an attorney, and just a quick summary. So what is a fiduciary? I've had people say, Dom, you shouldn't say fiduciary in a presentation. Nobody really knows what that word means. Well, a fiduciary basically is a person, or it could be an institution like a financial institution. And those people have a duty, and the duty is created by something they do. And they act primarily for another person's benefit. And it's important to keep those 3 points in mind, because the way somebody becomes a fiduciary is by their actions. I think many of us have been named by another person under their power of attorney to be an agent under a power of attorney, but you don't actually become the fiduciary until you go out and you undertake action related to the authority that's granted to you. So if somebody gives you that authority under their power of attorney, but you never act on it, you are not a fiduciary. Another important element of that definition that I used of fiduciary is you're acting primarily for another person's benefit. And that important element of a fiduciary is where a lot of fiduciaries get themselves into trouble, and that's something I'm going to talk about a little more in this presentation. So what are fiduciaries? Let me give you some examples of people and roles that are fiduciaries. Attorneys are fiduciaries. They're fiduciaries for their clients. An executor under a will who's appointed by the probate court, or if somebody dies without a will, an administrator who's appointed by a probate court, that's a fiduciary. A guardian of an adult with intellectual disability, or the guardian of the estate of a child who's not old enough to own assets in their own name, guardians are fiduciaries. Conservators are fiduciaries. Somebody who's a trustee under a trust is a fiduciary. I already talked about an agent under a power of attorney, and someone who's named in a healthcare document to be a healthcare representative for another person. They are also fiduciaries. Fiduciaries can be personally liable for their actions, and they're held to the highest legal standard in all of American law. That's a very important factor to take into consideration if you're considering performing as a fiduciary for someone. It's a very high legal standard. So what are some of the responsibilities that fiduciaries have? Well, they have to account for what they do. And it's important to keep very accurate records of what you do as a fiduciary in case somebody calls into question the propriety of what you're doing. Connecticut probate courts have equitable powers in dealing with fiduciary accounts. What does that mean? That means basically that even though Connecticut probate courts have limited jurisdiction, unlike the Superior Court, when it comes to looking over the accountings of fiduciaries, the Connecticut probate courts have all the power and authority that a Superior Court does. A fiduciary also has to follow something known as the prudent investor standard. And the prudent investor standard is complex law that talks about what a fiduciary may or may not do when they're dealing with the finances that are entrusted to their care. Now, that prudent investor standard can be altered by a will or by a trust, and that's important to keep in mind if you're preparing your own estate plan. The Uniform Prudent Investor Act, which has been passed into law in many states, Connecticut being one of them, applies to trust, applies to fiduciaries, and it requires fiduciaries, it requires trustees to follow the prudent investor standard. And it basically means they need to act, the fiduciary must act as a prudent investor would. They have to exercise reasonable care, skill, and caution because they are dealing with someone else's assets and they are acting for the benefit of that other person. So what are some of the things that this Uniform Prudent Investor Act requires? Well, it requires that investments that the fiduciary is responsible for be diversified. So for example, if the fiduciary says, well, I'm going to take all this money entrusted to me and I'm going to invest it in my own business, that's a violation of the Uniform Prudent Investor Act, and it's also self-dealing on the part of the fiduciary. So that's not a good thing to do. There's also a responsibility under this act for the fiduciary to review the assets periodically. Saying that you're too busy, not looking at the bank account statements or the financial statements for a very long period of time could potentially be a violation of the act. They have to invest in and manage those assets completely and totally solely for the benefit of the person who entrusted them with those assets. I talked a little bit about self-dealing in that example of the fiduciary who took all of the assets under their care and invested them in the fiduciary's own business. Well, that is a perfect example of self-dealing. It's a very common basis for fiduciaries to be found liable, and it's really based on the fiduciary's duty of loyalty. The fiduciary's duty of loyalty is not to themselves, it's to the person who's entrusted them with their assets. The fiduciary is prohibited from making a personal profit from the assets and funds that are entrusted to their care, and they're prohibited from deriving a personal advantage from their role and their dealings as a fiduciary. Self-dealing is, as I said earlier, a very common basis for fiduciary liability. And it can be very overt. It can be as overt as that fiduciary taking the assets that are entrusted to him or her and using them for his or her own benefit. Or it could be very insidious over a period of time. Maybe they start taking a very relatively small amount of the assets entrusted to them for their own use, but over a period of time it increases. And I think we've all seen news accounts of people who've embezzled money in businesses, for example, or as trustees or as administrators or executors. You know, it starts as maybe a little bit of money here or there, and after time goes by, it actually adds up to a lot of money. But certainly it's not the amount of money that is used in that way. It's simply the fact that the fiduciary is taking money that's not theirs and using it for their own benefit. So what are some signs of trouble if you're dealing with someone who's a fiduciary? Well, one sign of trouble is when that fiduciary acts outside their scope of authority. What is scope of authority? Where does the scope of authority come from? Well, it comes from a variety of places. It comes from our laws. That's a common area. And we have a number of laws in Connecticut called the Fiduciary Powers Act in the statutes that talk about what authorities a fiduciary may have. There's also case law. Case law is how our courts interpret the statutes and apply them to particular fact patterns in cases. Instruments, and I'm not talking about a guitar or piano here. Instruments are things like a trust or a will or a power of attorney. Those documents, if they're properly drafted, will outline what authorities the fiduciary will have and what authorities the fiduciary will not have. But in any case, if the instrument is silent on authority, then the fiduciary does not have authority that the instrument is silent on. And then another source of authority is a court decree. So for example, somebody who's an administrator is someone who's appointed when a person passes away without a will. an administrator really has no authority except that which the court gives it. So if someone's an administrator of an estate of a relative who passed away and there's assets that have to be sold, that administrator cannot sell any of those assets until they first go to the probate court, ask for permission, and the court grants them permission to sell those assets. Other signs of trouble for fiduciaries are failing to understand what their responsibilities are. Being on the bench for 17 years now, I've come across many cases where fiduciaries have acted for a long period of time as a trustee, as an agent under a power of attorney, maybe even a guardian, and then a relative comes to the probate court and they say, "Judge, I want this person to account for what they did," and that person says in court, "Well, I didn't know I had to do that. I didn't know I had to keep track of things. I didn't know I had to keep records." Well, unfortunately for those people, ignorance of the law is not an excuse to not follow it. And some of them get themselves in very difficult situations because they were very sloppy, very unorganized, and really derelict in their duties. Another problem that can occur with fiduciaries is someone not taking their responsibilities seriously. We're talking about assets, we're talking about income, we're talking about taxes here, and there are certainly many examples of fiduciaries who are far more interested in going away on vacation or going fishing than doing what they were supposed to do pursuant to their fiduciary duties, and as a result, the estate, the assets of the person whose assets they were entrusted with suffered some significant losses or maybe some significant tax liability that could have been avoided if they took their responsibilities more seriously. Failing to properly prioritize their fiduciary duties is another common source of trouble for them. And then of course there's the situation where there's conflict between the fiduciary and perhaps the family members of the person for whom the fiduciary is acting. My personal belief is if someone is acting as a fiduciary, they need legal counsel and they may need tax counsel. They shouldn't be undergoing that responsibility without the advice of proper professionals. Other signs of trouble are poor record keeping, lack of organization, and procrastination. For example, in your estate plan, if you're putting an estate plan together and you're thinking about who you want to appoint as a fiduciary for your will, under a trust you might have, or under a power of attorney, you want people who are very organized, who don't procrastinate, and who keep very good records. We all know people who do that very well, and we know people who don't do that very well at all. And when you're thinking about who you want to choose for your own affairs in your estate plan, you really need to think about someone who's not only trustworthy, but someone who's organized, who has a sense of importance about what their duties are, and is not going to procrastinate. Co-fiduciaries, sometimes we have more than one person serving as a fiduciary. For example, you can name more than one person to be your agent under a power of attorney. You can have more than one trustee acting under your trust at the same time. These co-fiduciaries need to be accountable to each other. And if they're not accountable to each other, that they can get themselves into trouble. I've seen situations where there's more than one fiduciary. One of them engages in self-dealing, maybe steals some money. The other fiduciary says, "Well, I didn't know they were doing that," but guess what? They're still responsible for the action of their other co-fiduciary, because co-fiduciaries are supposed to be keeping an eye on what each other does, and they're supposed to be keeping an eye, most importantly, on the estate and assets that are entrusted to them. And just because there's more than one fiduciary doesn't relieve any one of them of their responsibilities in that area. So I talked a little bit about how important it is, if you are a fiduciary, to have an attorney advising you. One of the reasons why people often don't get attorneys when they need them is they just don't know how to choose an attorney. They get very intimidated by the process, and I'm going to do a separate presentation on how to choose an attorney, but I thought I'd take this opportunity to briefly talk about some important things to consider when you are choosing an attorney. In a multi-lawyer practice, in a law firm where there's many attorneys, who is going to be your lawyer? Who is going to be the attorney who does the work on your case? A lot of times you might go into the law firm and speak to a senior level attorney, but once you pay your money and you sign the representation agreement, you may never see that senior level attorney again. All your work may be delegated off to a junior level attorney with very little experience, or perhaps a paralegal or an administrative assistant. So be careful of that. Other mistakes that you need to avoid when you're choosing an attorney is not understanding what the scope of the representation is. The rules of professional conduct in Connecticut say that an attorney needs to let a client know, a new client know, what they're going to be doing. And that's called the scope of representation. And that really should be done in writing, and you should understand what it is before you have any obligation or you sign any document to engage that attorney to work for you. You also should be careful about attorneys who are too busy to spend enough time with you. An attorney needs to take their client responsibilities seriously, and in my mind that means taking the time to understand what your concerns are and what your priorities are. They also should take the time to counsel you, because the rules of professional responsibility say that attorneys have a role as a counselor, and explain what your options are. If an attorney is not willing to do those things for you, I think that's a red flag, and you would be well advised to consider a different attorney. What are some red flags when you're trying to choose an attorney? Well, any pressure to retain an attorney, I'm really busy, you got to sign now, I might not be able to represent you next week. That is not a good reason to retain a particular attorney, and that kind of pressure is not appropriate, in my opinion, in a profession such as the practice of law. A failure to return your phone calls. If you call an attorney, if you email an attorney, they should reply to you within a reasonable period of time. And one of the most common reasons for grievances filed against attorneys is failure to communicate with their client. An attorney should keep you updated on your matter. You should know what's going on a regular basis. The attorney should be updating you. If an attorney misses deadlines, whether they're deadlines to you or deadlines to the court, that could be a real problem and can have very significant and serious consequences. A dismissive attitude toward your concerns is another reason why maybe that particular attorney wouldn't be the right fit for you. Any attorney who has disciplinary violations is someone that, in my opinion, you should not be considering for representation. And one lawyer who practices in many areas, the jack of all trades, I think in this day and age where the practice of law is getting increasingly complex, where the changes in the law are coming faster all the time, I think it's virtually impossible for a single lawyer to effectively practice in many, many areas. Certainly in a bigger law firm, you probably have attorneys who practice in particular areas, and that's fine, but a general practice attorney who does 7, 8, 9, 10 or more areas of practice, I don't think it's going to be a good approach to the modern day practice of law. Impatience with clients is a red flag, and preying on fear of the probate process. I've seen that in what I call the document mill type estate planning law firms, where they do these elaborate presentations, they cause people to be afraid of the probate process in order to sell their expensive one-size-fits-all living trust packages. Fear is not a reason for you to retain any attorney, and any law firm that uses fear as a tactic to try to get you to spend your money with them is not practicing law in the best way they should. So in summary, understanding the responsibilities and limits of the authority of a fiduciary are very important. The penalties of breach of fiduciary duty can include financial penalties and even criminal penalties, and it's difficult, if not impossible, to function as a fiduciary without having an attorney advising you. Estate planning and probate are very complex, and they're best saved for attorneys who focus their practice in those areas. The sources of authority and how they interface is extremely complicated, so really what you need to do is consult a qualified attorney with substantial experience in the area in which you have an interest if you need an attorney, and avoid attorneys who practice in many areas. Thank you.